The final case I will be discussing today is Cobble Center LLC versus Somerville Redevelopment Authority. The Cobble Center case presents another situation where the Supreme Judicial Court has been asked to review a municipality's attempts to take certain blighted property, in this case to create a more productive use and to provide a public benefit. Now, in full disclosure, prior to coming to the Division of Local Services some time ago, I was city attorney for Somerville, but I had no involvement in the underlying issues of this case. So with regard to the present case, instead of the General Laws Chapter 79 eminent taking statute invoked in the Abu Zawra case discussed previously, the SJC this time is charged with analyzing General Laws Chapter 121B's eminent domain authority, which provides for the creation of housing and urban renewal and the power of local redevelopment authorities to respond to, quote, decadent, substandard, and blighted open areas. The underlying facts in this case concerned a large commercial development in Somerville that had become stalled. The background as to why the development floundered involved a dispute among the investors in the development, which is located in an industrial neighborhood. Back in 2013, the developers had gotten zoning approval from Somerville to raise a single-story strip mall containing such businesses as a convenience store, a laundromat, and an eatery known as Potato Freak, and replace it with a 6-story building containing 5 stories of residential units and 1 story of commercial spaces. The developers then began clearing the property and removing the tenants and surrounded it with construction fencing. In 2014, however, one of the developers sued his partners, claiming that the project was too risky. He then removed his assent from the project. The ensuing court battles among the partners was finally resolved this past August 26, 2021, about 2 weeks ago, when the SJC decided that the hesitant partners' objections were not valid. The inaction of the project drastically altered the investors' dreams, however. In the intervening period, starting from 2013 on, city officials began to tire of the lack of development at the project and the lapsed permits and the resulting urban blight. And then the city began making other plans. Also, in the intervening time frame, the Massachusetts Bay Transportation Authority had commenced a decades-long plan to extend the Green Line subway line beyond Leechmere Square in Cambridge and into Somerville and Medford. A new subway station was to be built across the street from the stalled project and is about to open next year, vastly expanding development potential in the project area. The Somerville Redevelopment Authority, or SRA, is the city's urban renewal agency charged with implementing the city's urban renewal plans pursuant to General Laws Chapter 121B. In 2019, the Redevelopment Authority, in order to facilitate more enlightened development of the property, given the changed circumstances, decided to utilize the powers of General Laws Chapter 121B, Section 46F, which empowers urban renewal agencies to create so-called demonstration projects for the prevention and elimination of slums and urban blight that are not otherwise defined in any sections of General Laws Chapter 121B, the Urban Renewal Statute, nor are they defined by agency regulations. In 2019, the Redevelopment Authority adopted a demonstration project plan seeking to transform the property as part of a larger revitalization of the neighborhood, which would include a mix of dynamic, transit-oriented development and other economic drivers, and allow for the city to construct a long-needed new police station. The SRA believed that such a demonstration project would serve as a model, innovative approach to community development that combines a public uses successfully integrated with private development. With respect to the Redevelopment Authority's desire to utilize the demonstration project to spur economic development of the area, the Redevelopment Authority noted that the demonstration project concept under Section 46 was an alternative to the full urban renewal option that required a lengthier review process. In accordance with the demonstration project plan, and after strenuous objections from the developers, the Redevelopment Authority utilized its eminent domain taking authority under Section 46 and took the property by eminent domain. Next slide, please. The central question to this case involved the determination of whether the Redevelopment Authority's taking of the property was authorized by General Laws Chapter 121B, Section 46. The developer argued that the legislature did not empower the statute to allow eminent domain taking authority for demonstration projects. Such takings were only allowed for urban renewal projects and required full redevelopment authority plan review. At the trial level, the Superior Court supported the Redevelopment Authority's position, that is, that demonstration projects like typical urban renewal projects contain eminent domain authority. The SAC took the matter up on appeal, and the Supreme Judicial Court noted that the question of whether General Laws Chapter 121B, Section 46F, demonstration projects may utilize eminent domain taking authority is a case of first impression. The Supreme Judicial Court reviewed the scant legislative history and court precedents, as well as statutory construction issues. The SJC ultimately concluded that the Redevelopment Authority's eminent domain power was not limited to full urban renewal projects under General Laws Chapter 121B, Section 45, and are allowed for demonstration projects even without a full review. Next slide, please. The developers next argued that the demonstration project utilized by the Somerville Redevelopment Authority for a mixed-use project involving the construction of a public safety building and transit-oriented development was flawed and wasn't a demonstration project at all, but just a run-of-the-mill urban renewal plan that required a full-scale Redevelopment Authority review. The SJC noted that General Laws Section 46F does not sufficiently define demonstration, nor did the Redevelopment Authority identify with great precision what made its project unique. Nonetheless, the SJC reviewed the Redevelopment Authority's demonstration project and found that it is a valid demonstration project under Section 46F. In its conclusions, the SAC did note, however, that advocates of future demonstration projects must identify in clear detail the characteristics that define them as demonstration projects. The SAC then took up the developer's claim that the taking was unconstitutional. Next slide, please. With respect to the developer's argument that the taking of property by a governmental entity for the purposes of blight elimination was an unconstitutional government exercise of power, the SJC found in favor of the Somerville Redevelopment Authority. The Supreme Judicial Court reviewed the 2005 United States Supreme Court holding in Kelo and applying it to this case, concluded that the taking of property for economic development and blight elimination was a valid public purpose. The SAC concluded that demonstration projects must in the future articulate that they eliminate blight, in addition to the previous section where the SAC stated that such projects must demonstrate uniqueness.